Next area of topic are arbitration agreements, and I'll quickly go through some advantages and disadvantages of arbitration agreements. Advantages are obviously that you would be dealing with a single plaintiff as opposed to a class action or multi-plaintiff arbitration. They tend to be less costly than jury trial. There are, motions and other arguments that are time-consuming and extended in a jury trial, whereas those don't necessarily happen in arbitrations. It's much more streamlined process. Also, unlike juries who may feel sympathetic to a plaintiff or antagonistic to an employer and award larger sums, including excessive punitive damages, arbitrators may be less inclined to allow their personal biases and emotions to affect their award. In fact, arbitration awards consistently are smaller than jury awards in similar state and federal litigations. Most importantly, in employment cases, advantage of an arbitration agreement is that it has a class action waiver, which eliminates the class action for the employer. And settlement costs associated with defending class actions go down significantly. The lack of potential runaway jury in a large class action also has the advantage of reducing settlement value significantly. In mediations and settlement discussions, plaintiffs' attorneys are unable to leverage the looming unpredictable jury potentially, and they lose that leverage by having a collective class action motion that potentially will be filed, certifying the class as a leverage to get significant damages. Finally, arbitration agreements can protect the employer from unwanted publicity. As you know, arbitrations are confidential, unlike court hearings. Courts are inherently public forums. With few exceptions, anything filed in a court is open to the public. Proceedings are open to the public. And so some employers may have reasonable concerns about litigating internal work-related disputes in public trial. So by contrast, arbitrations are private and are not advertised to the public, to speak. Some of the best practices, if you do decide to, actually some of the disadvantages of arbitration agreements, they, although they're cheaper than a jury trial, arbitration costs can begin to get higher. In employment arbitrations, employers must pay both the employer and the employee's share of the arbitration expense and fees. And in addition, the employer is also responsible for paying their own attorney's fees and costs. So that can add up to be significant. Hearing time fees charged by most arbitrators, provided these days can exceed $40,000 for a 3-day hearing. And there are also associated costs for moving to compel an arbitration agreement. If employees dispute that there is an enforceable arbitration agreement, there is an added cost to move to compel it and defend against a challenge by an employee. So that's where a carefully worded arbitration agreement can reduce these costs, and they can be eliminated. Finally, there's almost no appellate review of an arbitration award. So those are some of the disadvantages. If you do decide to implement arbitration agreement, given that the class action waivers are enforceable, that's a huge advantage for employers, and most employers prefer to implement arbitration agreements based solely on that ground. And if you do proceed with an arbitration agreement, you want to make sure that the agreement is enforceable to begin with. It has to be drafted in a way that it can withstand a challenge in court on enforceability. One of the best things to do is to have a standalone document, prominently advise the employees that giving up certain rights. A standalone document is best as opposed to having it in an employee handbook. That's not to say you can't have it in an employee handbook, but employee handbooks and its acknowledgement form typically state that the handbook does not create an employment contract. So for that reason, you don't want to necessarily have an arbitration agreement in the employee handbook. Another benefit of using a standalone agreement is that it has to be entered in a public record to enforce the settlement, enforce the agreement. And if it's in the employee handbook, you don't want to enter your entire employee handbook into evidence in a court. Another thing to keep in mind, if you have an arbitration agreement, that if you that if you have a population that doesn't speak or understand English, that it's translated into the language that they are able to understand. And so if you have a Spanish-speaking employees, make sure you have a Spanish translation of the arbitration agreement. Make sure that the arbitration agreements are signed. If you have electronic signatures, make sure you have processes in place and somebody, an employer representative who can testify in a court if the electronic signature is challenged with respect to the authenticity of the electronic signature and being able to establish that it is in fact the employee's electronic signature. Next, you want to make sure that the employees have time to read the agreement and an opportunity to ask questions before signing it. Give employees a copy of the agreement. Train your supervisors and HR in terms of making sure that the agreements are properly implemented. They follow up with the parties to make sure that the agreement is signed. Implement a system to track who signed the arbitration agreement and who has not signed it. This is especially important when you are facing, let's say, a class action. We want to be able to quickly gather, as far as the individuals who are part of the class, how many of them have actually signed arbitration agreements that include a class action waiver. That drastically can reduce the putative class size for purposes of class action exposure. So being able to keep track of that is very important. You can easily and quickly gather that information. When implementing an arbitration agreement, if you are implementing an arbitration agreement and have a pending class action or a PAGA action, the arbitration agreement has to include that. Another key thing to remember is once you have a case that's already in arbitration, the employer must timely pay the arbitrator's fee, or the fees, the invoices that are issued by the arbitrator must be paid immediately and in a timely manner. Those invoices are disclosed to the plaintiff's attorneys so they know when these fees are due. And courts actually now allow plaintiff's attorneys to file an action to bring the action back to court if an employer delays paying the arbitration fees. So that's an important thing to keep in mind. And finally, make sure you have a regular review of your arbitration agreement by counsel, at least on a yearly basis, because arbitrations in employment are constantly being challenged and the landscape is constantly changing, and you want to make sure that your agreements are in compliance each year.